Okay, welcome back. Welcome back. All right. Any questions? Anything on your mind? Okay. Let me show you. I mentioned it briefly. Um, the midterm. I just want to show you what this looks like and walk you through it briefly, so you have a little bit of background. Bring this up. Come on, load, load, load. All right. So when you go to the syllabus and you scroll down, you will see a lot of old exams. I have posted every exam I've ever given with the A plus answer. Where I suggest you start is right here. The midterm from spring 2018, which was basically 6 months ago. I have the exam, the A plus answer, and the memo. Okay. I would suggest that before next Wednesday, so basically a week from today, you take this exam in full. And let me just run you through it briefly. Okay. All right. And all my exams look identical, so if you see one, you'll see them all. So the midterm, I have 90 minutes for midterm, 1,000 word limit. Okay. When you first get the exam, it's short. The entire thing's about 2 pages long. I try to keep it as short as I can. It's deceiving, though. The shorter the exam is, the less information I give you to help you. You actually prefer a longer exam because it gives you more stuff to work with. So actually, a shorter fact pattern makes it a lot tougher for you. So when you first get the question, the first thing I suggest you do is read the first sentence. It might be hard for you to see, but it says the year is 1803. Okay. The reason why you start off with the instructions, is so you get the right time frame. That will tell you immediately what period you're in, what cases you should cite, and what cases you should not be citing. So it says the year's 1803. You're clerk to Levi Lincoln, who was Attorney General to President Jefferson. By the way, these are all true facts. I give you basically history, and I twist it a little bit. It's all very accurate. I put a lot of time into that, actually. Your answer has 5 issues and more than 1,000 words. The next thing I suggest you do after you read the instructions is go through the prompts. And I usually do it like this, where I'll give a paragraph or two and do question number 1. And then here a sentence or two and question number 2. And then another paragraph to question 3, another paragraph question 4, another paragraph question 5. Before you even read the paragraph, I would first read the actual question, the prompt. The reason why is that this puts you in the right frame of mind so you know what I'm looking for. It helps to focus you. If I want to make this exam harder, I would simply say, please discuss all relevant issues, right? I would never do that to you because that would give me answers that are all over the place. I want you to answer the questions I'm giving you, not go on a tangent of whatever you think is worthwhile discussing. So read each of the 5 prompts, then go back and read the questions carefully. My recommendation, you should not start writing your answer until about 20 minutes in at a minimum. Take at least 20 minutes to really read the question carefully. You will save time on the back end if you postpone writing. If you start writing immediately, you're going to screw up. It's not possible to do it this quickly. The questions will ask you different things. Maybe you've learned something directly on point, but more likely you've learned something that relates to it, and then you have to bridge the gap. What do I mean by that? You say, the facts here are similar to case X versus Y, but they're different in one regard, and here's why that difference makes the outcome come out in a different fashion, right? How are the cases you studied similar or different to what I'm asking about, and why will that difference maybe change the outcome? Again, I take stuff you've learned and I twist it around. I flip it, invert the parties, maybe change a really important fact that might make the case come out a different direction. And your job is to spot that and to spot how I'm trying to trick you and how I'm trying to flip things around. That's what makes this exam really difficult. What made this question really tough from, I think this is Arlene's midterm last year, is you're in year 1803. So basically you have no cases to cite, right? Marbury, I don't think had even been decided yet. Maybe Marbury was 1803, so maybe you have Marbury, but that doesn't really help you. You have to look at authorities you have given to you. One last point. The fifth question is what I call the policy question. It's something much broader. So here, it discussed whether President Jefferson should propose an amendment to the Constitution, right? There's no case that directly implicates that, but there is a case that's relevant. So the setup of the question was this. President Jefferson considered amending the Constitution to give Congress the power to acquire property, right? At that point, he had already done the Louisiana Purchase. And we discussed this. It was unclear if Jefferson had the authority to purchase Louisiana Purchase. We mentioned this class. I mentioned it briefly, but trust me, I mentioned it. So Jefferson was saying, should I amend the Constitution to basically ratify what I had done before, right? What's the cost of that? Well, if you ratify it, that suggests that he lacked the authority in the past. But the upshot is this ensures in the future you have this authority. Now, you're saying, wait a minute, Josh, we didn't do any cases involving constitutional amendments. We actually did. Anyone know a case? A very important case involving an amendment to the Constitution at this time was already decided. Anyone know what it is? This is what the A+ paper got. What case from this really early, 1790s? Yeah.
Wasn't the one where they he was wanting to sue the city Hans? He wanted to sue the citizens.
You're really close. It's not Hans.
And then it was the 11th Amendment that they amended.
Chisholm, right? And if you recall, Chisholm corrected, perhaps, a decision of the Supreme Court. So if you actually read the fact pattern, it's going to jump out. It's like, oh my God, he's talking about Chisholm, right? You're basically passing a constitutional amendment in response to a court decision. Right? So again, it's not obvious what I'm looking for. But if you really think about it, it's going to jump out at you. One other caveat. The exam won't always be you're a judge. Right here, you're writing a memo for the Attorney General of the United States. And I think it's a different responsibility if you're a judge versus an executive branch member. You have different considerations. Court precedents don't have the same sort of weight. So keep that in mind, right? I can say you're a lawyer for a member of Congress, perhaps. Remember where you're situated. And that will, I think, inform how you write your answer. Now, next I want you to go back to that page and click on the memo. So after you've done the exam for yourself, give yourself 90 minutes, go read this memo. I wrote a 4-page memo, very detailed, where I explained step by step what I was looking for. I didn't do this every year. I only started doing this last year, so unfortunately I don't have these for all the exams. But go through the memo very carefully and just see what I was looking for. This will be far more helpful to realize what you missed than anything I could ever do. And then go to the A+ answer. Again, this is what I call hybrid A+ answer, where I took the top students for question 1, I put there the top student for question 2. So it's everyone's top paper, all 10s basically. It will probably go over 1,000 words, but this is everyone's top paper. And then compare your paper to this and see what you're missing. Right? It doesn't have to be perfect, right? But this puts you in the right ballpark. Do this midterm before our midterm a week from today. Take some time this weekend. I would suggest your Langdell's on Saturday. It might not be possible to do it beforehand, but at least do it after the Langdell, maybe on Sunday, so you know what you're expecting. If you can do it beforehand, great. If not, after. And please take this seriously. At some point after the midterm, I'll circulate a link. Doodle, which is a thing to sign up for scheduling. I'll have I have 55, I have 100 slots, so you can just pick one. I'll have them on a Sunday and also have some evening slots as well, basically after this class. If you're not tired enough at 9:30, you can stick around a little bit later. But if you can't come on a weekend, that's your alternative, unfortunately. But I'll be here as late as you need me to be here. All right, any other questions? Questions? I know you have questions. You don't want to ask them. No? Nothing? Okay. All right, let's get started then. Today we continue our discussion of the 14th Amendment. Last class focused on one provision of the 14th Amendment, which was the Privileges or Immunities Clause. And we studied in the slaughterhouse cases how the court said that this provision refers to a very narrow set of federal rights. The butchers lost. Ms. Bradwell lost. She wanted to be the member of the bar. And then we did the Cruikshank case, which was always an awful case to teach. And in that case, the court held that the privileges or immunities of citizenship did not include provisions of the Bill of Rights, such as the right to bear arms and the right to assemble peaceably. Okay? Our unit today continues the trend where the Supreme Court reads narrowly every single aspect of the 14th Amendment. Within a span of barely 20 years after the 14th Amendment was ratified, the provision didn't have much salience. So we start off okay with the Privileges or Immunities Clause. Today we have 3 cases. Actually 4 cases, I'm sorry, I can't count. We have Strada versus West Virginia. We have the civil rights cases. We have Yiquo, and we have Plessy. Each of these 4 cases, well, actually not Strada, not so much, but the biggies, right? Civil rights cases and Plessy narrowly constrained the 14th Amendment in very profound ways. So I want to start off here by posing a question. Okay, let's see, ConLaw. Okay. So here's your question, right? Is it true or false? And I think this will help put us in the right frame for the discussion today. Strouder found that West Virginia's jury segregation law violated the Equal Protection Clause of the 14th Amendment. I think most law professors will get this question wrong. I would have gotten this question wrong about a year ago, I think at least. Strouder found that West Virginia's jury segregation law violated the Equal Protection Clause of the 14th Amendment. True or false? All right. Another 10 seconds. People are slowly trickling in. Is it not working? It's good when things work. Okay. Who? Where did I drop off last class? Who's next? Delbert, you next? All right. What's your thinking? Were you here last class? No, oh God, I can't read that. It's too faint. What did I say? Jason, were you here last week? Okay. I called you last?
No, you called me.
Drew, okay, Delbert. Okay, so Delbert, what's your thinking here?
So it was definitely unconstitutional under the 14th Amendment, but I believe they relied on the 5th Amendment, talking about the powers to enforce.
Delbert, let me ask you a question. After this case, did West Virginia start admitting people of African descent onto their juries?
No.
They didn't. So then what was the actual outcome of Strouder? What was did the court actually declare unconstitutional West Virginia's practice of excluding black people from the juries?
That the state statute limiting jury service, yeah, they did say that was unconstitutional.
So after this case, West Virginia start admitting black men into the jury?
Well, they did not.
So where's this disconnect? I thought if the court says something, people got to do it.
So the power, I guess, to police is held by the state. So the police powers are held by the state. But they're saying there's the 5th Amendment that gives Congress the power to enforce the 14th Amendment.
You mean Section 5?
Section 5, right.
All right, Jason, let me ask this question. Did Strouder challenge the West Virginia laws being unconstitutional? What did Strouder actually want here? What was his remedy that he actually wanted?
He wanted a fair trial with persons that represent him in a jury.
And where did he think he was going to get that fair trial?
Not in the state court.
Where did he want to go?
The federal court.
Ah. right? This is the rub, and I think I would have gotten this question wrong about a year ago. In almost every single case book, in fact, in ours until, notice that this case is not in our book. I give you like a separate supplement. I only discovered this over the summer when doing some research. In every single case book that I've ever seen, the book says that Strouder found that West Virginia's law was unconstitutional. It absolutely did not do that. It did not do that. That was not the basis of the court's ruling. The basis of Strouder was the removal statute, right? So you all know about federal removal, right? You do this in civil procedure, right? That if I sue you in state court, and on the face of the complaint there's some sort of federal question, right? I can remove it to federal court. Or if I sue you and you're a diverse party, and there's a $75,000 amount in controversy, I can remove it from state court to federal court. We all know this, right? But Congress enacted a very specific, by the way, I think the answer is false here. I think, let's see. Yeah, okay, most of you got that. Very good, 65%. That straight up curve. This case, so I think, is unique because Congress passed a removal statute, a very specific removal statute, right? And what was the purpose of that removal statute? If you could not get, quote, the equal civil rights of citizens of the United States in your trial, that if you were convicted of a crime, right, and your trial was not giving you the equal civil rights of citizens of the United States, you can take your business to federal court. Everyone understand? Congress enacted a number of laws following the 14th Amendment. And these laws exhibited a distrust of state proceedings. They distrusted state legislatures. They distrusted state executive branch officials. And they distrusted state courts. And in particular, in 1875, Congress enacted what was called an Enforcement Act. An Enforcement Act. And the Enforcement Act says if you are charged with a criminal offense and you're not getting the equal civil rights of citizens of the United States, and you're a citizen now, you can take this case to federal court, where presumably a federal judge can throw out bogus charges. Now, this case, I had always simply assumed that Strouder was set up on some sort of bogus charge. I just assumed. I never actually looked into it. Apparently, he was charged with killing his own wife, and it was a very gruesome affair. I found some old newspaper clippings on this. It was pretty bad. I can't find any pictures of Strouder, but apparently he killed his wife with an axe. It was really gruesome. It was like a huge, like, what do you call it? Like today we have these celebrity murders. This was like a celebrity murder where the guy killed his wife with an axe, and the daughter was in the room, and she witnessed it, and like there were brains everywhere. It was really gross. But yeah, no, it was gross. But I'd always assumed that this was some sort of bogus charge. They're trying to set the guy up, but there actually was a crime convicted. But anyway, Strouder contested that his trial was unfair because they excluded black men from the jury. By the way, no women in the jury, right? This wasn't just anyone. There was men or only men. So it was excluding black men from the jury. And he claimed he couldn't get a fair trial. Now, he didn't go up and say that his own trial, he didn't claim necessarily that the West Virginia law was unconstitutional. He relied on the federal removal statute to get himself out of federal court. So the actual issue was, did the federal removal statute, did Congress have the power to enact this federal removal statute? Right? That was the basic question in Strouder. It wasn't an equal protection case where we think of it today. It didn't say that the West Virginia law was unconstitutional. If it said that, then West Virginia kept violating the law for decades to come because they didn't admit black men in the jury for a very long time. The question was, could you drag this out of federal court into out of state court into federal court, right? So, Ross, I think we're back up top. Ross, what power gives Congress the authority to enact this removal statute? I always have to ask the question, where does Congress get the power to enact this removal statute? Necessary and proper? Good guess. Necessary and proper for what, though? What enumerated power does it link to? That answer is basically correct for the first half of the semester, doesn't work the second half of the semester. Right? Where does Congress get the power to enact this removal statute? What topic are we studying today, Ross?
14th Amendment.
So where does Congress get the power to enact this removal statute?
The 14th Amendment.
You gotta be more specific.
The Equal Protection Clause.
You gotta be more specific. Does the Equal Protection Clause give Congress power?
Oh, I think it was Section 5.
Section 5. All right. Let's take a look at Section 5. Right. Section 5 is a very important provision of the Constitution. Okay? It says, the Congress shall have power to enforce by appropriate legislation the provisions of this article. Okay? One of the provisions of this article is, as Ross said a moment ago, the Equal Protection Clause. Think of Section 5 as like a necessary and proper clause, right? Not exactly, but it operates in a similar function. You have the Equal Protection Clause, which says states can't do something. They can't deny to someone the equal protection of the laws. And if they do, Congress can step in and enact legislation to remedy that problem. So if a state is depriving someone of a fair trial, for example, that's failing to afford them the equal protection of the law. They're not being protected by the law against these unfair charges. Now, here's the key point. The court didn't simply say, because the jury was not properly constituted, the conviction's tossed out. Right? That's not what happened. If the court didn't say, because the jury was segregated, we're tossing out its conviction. All that was at issue was, can it be removed to federal court? And indeed, the court says, Jessica, was the removal statute constitutional? Tell me why. Why was the removal statute constitutional?
I just remember it was talking about this. It was within like the state's action, like it's a state action. So. Oh,
okay. What does that mean, state action?
Like the state has to do something.
What was the state doing wrong here? Let me ask the question like that, Jessica.
They were, well, they were denying him equal protection.
How? Specifically, what about the segregated jury pool deprived him equal protection of the law?
Well, I guess it deprived him of due process because.
So you just switched to a different clause, right? Was this about due process?
It's kind of both.
All right. Jesse, you want to take a stab? Yeah, no, you have no choice. I ask you, but it's not, Justice Stevens, when he was on the court, he'd always go, counsel, may I ask you a question? And the answer is always, of course, yes, ask me whatever question you want, but he would always say, counsel, can I ask you a question? So, Jesse, would you like to answer the question?
Can you repeat the question?
Damn it. What was the basis of the finding that the segregated jury law deprived Strouder of equal protection of the laws? What's the argument there?
I'm not sure.
Anyone? What's up? Oh, you're next, Dana. Yes, go for it. Oh, perfect. This is great. Yeah.
Are you getting at where they mentioned they're singled out and practically?
Yeah. Go down that road. Go for it.
They're placing a brand upon them affixed by the law that's an assertion of their inferiority.
Okay, and I think that's a good place to start, right? The fact that people are being excluded from the jury suggests there's an inferiority of the races in a very important aspect of our polity, which is jury service, which was essential to any sort of criminal conviction. Okay? Because this statute that segregated the jury pool violated and denied equal protection, that activated Congress's powers, right? Think of it this way. Once a state deprives people of the equal protection laws, it activates a congressional power. And then Congress can use that power to swoop in and pass laws, like the Enforcement Act here. And the purpose of that law is to prevent the violation of the 14th Amendment. So therefore, Congress said that we find that if the jury pool is being segregated, that the way to remedy that is by dragging the case out to federal court, where presumably the jury pool will not be segregated. I think is the case, but presumably it will not be. So the basis then of this law was Section 5 of the 14th Amendment. Okay? Yeah.
So when you say swoop in, it's when the state is violating those rights?
Yes. When the state is failing to afford the equal protection of the laws. And I think Jessica mentioned this point a minute ago. The word state there actually plays a lot of work. It does a lot of work. And we'll see this in the next case, civil rights cases. When the state's not acting, the court does come out a little bit differently. Okay, but everyone get the outcome of Strouder then, right? Because there was a deprivation of the equal protection of the laws, Congress's Section 5 powers are activated, which allows them to drag the case out of state court into federal court. Okay, everyone get Strouder. Yes, Sergio.
So, I mean, I have on my notes here that Strouder did say that the law was unconstitutional.
But did they
never answer that question.
declare it unconstitutional though?
The court never
See,
said it was
that's the rub, and this is why almost every casebook I think gets it wrong, right? Okay. This is why I think almost every casebook gets this case wrong. They edit out the parts in Section 5. They just have that one sentence violates the 14th Amendment. They leave it there, but they didn't actually say because this law is unconstitutional, it can no longer be applied, right? Generally, when the court says that something is unconstitutional, that means the law can no longer be applied. Generally, right? That's not what happened here. Everyone see? Most books, and the one I used to teach did the same, they took the sentence Sergio quoted a minute ago and they just end it there. And say, aha. Even Judge Kavanaugh, during his hearing, mentioned Strouder like 5 or 6 times for exact proposition. I was like yelling at my TV. That's what I do when watching confirmation hearings. They always get stuff wrong. When I was my 3L summer, when I should have been studying for the bar, I was watching the Sotomayor hearings, watching the entire thing gavel to gavel, and I was like yelling at my TV the entire time. It's too much fun. But the case, that's what I do. The case didn't actually invalidate and set aside the West Virginia law. They said because this law deprives equal protection. And this is an important point. Today we think of the 14th Amendment as something the courts enforce, right? That if a state law violates the 14th Amendment, the courts set it aside. That wasn't what the conception was back then, right? Think of Slaughterhouse. We don't want to be a censor on state legislation, right? They didn't want to sit and invalidate state laws. What they were content to do, however, was allow Congress, in this case, to pass an enforcement act. Now, that would go out the window in the next case. Congress can't do very much. But at least here, they allowed the removal statute to go into effect. So I guess maybe I can make this question more precise, say invalidated. No, I don't want to say that. Held. Better. Court held. I don't think it was the holding of the case. Maybe that's a better way of phrasing it. And Clay, was your hand up a minute ago?
It was, but I forgot my question.
Fair enough. Mai?
I have a hard time now, after this case is all get fuzzy, and I have a hard time determining whether a case fit in the 13th or 14th Amendment.
What a good question, yeah.
And then the second thing, does it fit under the equal protection or due process clause? Because it seems like it can apply to all of the above.
Just you wait. Just you wait. Once we get to Justice Kennedy in the 14th Amendment, he doesn't care about clauses, and it all bleeds together. So we'll do cases where they say this violates equal protection and due process. Try to figure out why. So I can sort of separate due process and equal protection now. In about 2 or 3 weeks, I will not be able to anymore. The court blends them together. It basically means it's bad, right? We don't like it, so it violates the 14th Amendment. Which provision? Doesn't matter. In fact, Justice Kennedy has one line where he describes equal protection and due process like this interwoven thing that they wrap around each other. It's whatever. I am so glad I don't have to do Kennedy new stuff anymore. It's over. Yeah. They're horrible cases to teach, Kennedy stuff. Just you wait. Mia and then Yaron?
The majority talks about, like, there can be jury laws that can prescribe qualifications that make discriminations. Like being male or freeholders. There are things that I know we'll get to Equo and the like neutral on its face, but I mean, did that kind of open the door for Plessy? Like, I mean, it just kind of seemed like he's saying, because those are things like if you can say that, oh, they have to be a freeholder or things like that, things that weren't necessarily available.
Well, keep in mind, the crux of this case is whether a federal law is constitutional,
So
right?
it's
They weren't going to strike down the state statute. They didn't strike down the state statute. If you think of it this way, the bridge from Strouder to Yickwo makes a lot more sense. I'm sorry, from Strouder to Plessy makes a lot more sense, right? Go back to Slaughterhouse. We do not want to be a censor on state legislation, right? They don't want to get involved with that. Plessy was not involving a federal statute. It was only a state statute. And also, one second, I'll get to Kenesha in a second, Yaron and Kenesha. Another point is they make a big fuss about custom and traditions, right? They say there's a long tradition of having, for example, freeholders on the jury, right? People who own property, right? If you go to Plessy, which we'll get to later in class, they make a thing saying this is the custom and tradition at the time. They make a really big distinction of how things operated. Yaron and then Kenesha?
Mine was kind of off of the same comment she was talking about, because what stood out to me was when they said persons having education, no qualifications. I was just thinking once we get to like all the Jim Crow laws, that's where I felt like you basically told them it's okay for you to do that, but I guess we'll.
Well, also, what year is this? 1870? Let's just call it the year. 1880, yeah, thank you. This was fairly early in the Jim Crow era. And what you'll find is it got worse quickly, year by year. When Plessy enacted its railcar segregation law, that was a fairly new idea, right? That didn't really exist beforehand. And in fact, there's one line in the civil rights cases by Justice Harlan where he says, you know, can you pass a statute where black people walk on one side of the street and white people walk on the other side of the street? He was not speaking about current events, but only somewhat later did you actually start having segregation on the public highways. So the notion of excluding people from rail cars evolved after lesser things were upheld, right? So when you uphold a minor segregation law, then they sort of go a little bit more, and they go a little bit more, a little bit more, until you get the straight up separate and equal doctrine. Nisha?
I didn't understand the question that you were answering. So I was trying to get some context, because I feel like I missed something. What were you answering?
I forgot, what was your question, Mia?
I didn't get.
I don't remember what the question was.
So in the majority, they say that that the Virginia law, that there's an issue with equal protection, but that there can be jury laws that prescribe qualifications.
Oh, yeah.
Discrimination.
Yeah, so I think one of the aspects of the court's opinion is that they said general restrictions on the jury service that are customary and long-standing permissible, but this one, which is excluding black men from the jury, was not permissible. I think that's what Mia was asking.
Well, yeah, even though those other things really do invade equal protection. I mean, if you're requiring people to be freeholders and they haven't had their own freedom, much less income, like they can't.
So it was a closet, like a shield, but it was actually.
I mean, it's like you're saying that they can have facially neutral laws that make discriminations that actually violate equal protection, but because it's like, oh, that's custom, that's okay.
Okay, yeah, fair point. All right, so anything else on Strouder? Important case, very important case. It's one of the rare cases in this era where the civil rights litigant actually prevailed. There are not many from this time period where Strouder actually won it. And again, I can't remember if he was retried afterwards. I can't remember if they tried him in federal court. I just don't remember what happened. But yeah, just Google Strouder in West Virginia. It's like there was this gruesome murder, an axe. It's not what I thought it was. Yeah, Aaron.
And because of this, on the
not the video, but then you said he was vindicated, which means he just dropped all the charges were dropped?
I can't remember. I'm drawing a blank. I don't know if once it was removed to federal courts, if the case was dismissed. I'm drawing a complete blank, and I hate myself for it. But I researched this over the summer. I know there's an answer. I'm just blanking on it now. Yeah.
What happened to Field? Because in Slaughterhouse, he was on one side, and I noticed with Bradley too.
Yeah. So I mean, again, Justice Bradley gets around, right? He gets around.
But Field as well. He was with Bradley.
Yeah, Justice Bradley wrote the dissent in the Bradwell, the women lawyer case, right?
To explain why
Yeah.
Slaughterhouse was different than Bradwell.
But so what do you think of Justice Field then? You tell me. Okay, just say
He had an interesting life.
Well, what line? Tell me.
Apparently, he had a specially designed jacket so he could carry pistols in his pockets.
Okay, so Justice Field had an assassination attempt against him. There's a really important case called Ex parte Nagel, where basically Justice Field's bodyguard basically killed someone who was trying to kill him. He was an interesting dude, Justice Field. I can go on about interesting guy.
He went from in Slaughterhouse saying that there is a very clear, specific meaning to the 14th Amendment privileges or immunities to being like there's no power.
Yeah, he thought. The basis of his dissent, if I can summarize it, is that you don't need people to look like you to get a fair trial. I think I think he thought it was an affront to the idea of a jury, that the mere fact that you only had an all-white jury means you couldn't get a fair case. I think that, Tim?
Well, I was going to say, because he brings up the opinion that he wrote in Ex parte Virginia and actually quotes part of it.
Yeah.
I think his bigger concern was taking power away from the states. And he even mentions it in there in a couple of places where, Congress laying down rules to orders judges to do things. What's next?
Yeah.
Are we going to order the executive branches and their legislative branches to act as well?
Like a micromanaging, right?
Yeah, because he talked about it as a prohibitory power only against the state.
Yeah. Yeah, by the way, no other book has Ex parte Virginia. I had to dig and figure that out. It's not obvious that was even connected, so I had to sort of just splice it. But the Ex parte Virginia, I think, explains Field a lot more clearly. All right. Anything else on Strouder? Very important case. No, was that a hand? Okay. Yeah, Jessica.
So that I understand, so this case was only about equal protection, not due process, it's in the later case, because that's why
Look, so
both, but then in
yeah.
the later cases it talks about, I think the Chinese laundromat one, was like.
You want a case about a trial to be about due process, right? You just want it, but it not quite.
Okay.
But Yikwall, I think, does involve a liberty provision
Okay, so
or property of due process.
Okay.
Yeah.
I guess that's what I was thinking.
Okay. Let's do the next case. So the next case has a confusing name. It's called the Civil Rights Cases. And it was fairly common back then when you had lots of different cases that were appealed to the Supreme Court at the same time, the court would consolidate them and give them a nickname. Like, remember the lottery cases, the child labor tax cases? I wanted Obamacare to be called the healthcare cases, but the name just never stuck, and so whatever. But I was hoping for healthcare cases. People actually wrote a book called The Healthcare Cases, just the name never stuck, so whatever. This was called the Civil Rights Cases. And it involved another act passed by Congress, the Civil Rights Act. Okay? Clinton, are you next? You want to give me the facts, please, in the civil rights cases?
Sure.
Thank you.
So these cases arose when African Americans were denied access to things in the public domain.
Okay, good.
The business owners were indicted for violating the Civil Rights Act, which was passed,
Which Civil Rights Act? What year?
1875.
Yes, ma'am.
And
Okay.
it was entitled an act to protect all citizens in their civil and legal rights.
And by the way, the law in Strouder, I think, was 75 also, wasn't it? Check me on that. Was it 70 or 75? The Enforcement Act. 75. Anyway, I think 75? Yeah, thank you. Thank you for checking me. So basically, in the 1870s, Congress enacted a bunch of these laws. They enacted a lot of them that did a lot of sweeping things. And one thing to keep in mind is when Congress was enacting these laws, the southern states still basically had no representation, right? But slowly, as the 1870s chugged along, the southern states started to resume representation in Congress. So 75 was basically like the high watermark, right? The Civil Rights Act of 75, which was the issue in the civil rights cases, was like the high watermark of civil rights legislation. And Congress wouldn't really revisit this area until the 1950s, 90, 80 something years later. All right, so Glenn, go on, please. Continue.
And so kind of a breakdown was, two of the cases were because, students denying African Americans the privileges of an aim for her child.
Okay.
Two of them are denying, privileges and accommodations to a theater.
Okay.
And particularly was giving, a colored person a seat in the dress circle of the bar theater in San Francisco.
Uh-huh.
There's indictment brought against the defendant for denying another person whose color is not stated the full enjoyment of the accommodations of the theater known as the Grand Opera House in New York.
Okay, very good. All right, let's go for now. Okay, so this case, again, was consolidated. Congress passed a law that made it a crime to exclude people from certain places of a public accommodation on the basis of their race. This wasn't like, you get a slap in the wrist, you get a fine. This was a criminal offense. You go to jail for it. These were criminal indictments for segregation. And who they indict? The owners of these various businesses. So there was the Opera House in New York. There was McGuire's Theater in San Francisco, and I have some pictures up in your book as well. And these weren't just Southern institutions. They were in New York, San Francisco. They were all over the country. Okay? All of the people who were indicted with these crimes raised the same defense. They argued that Congress lacked the power under Section 5. They lacked the power under Section 5 to enact the statute. They also argue that Congress lacked the power under Section 2. Wait, what the hell is Section 2? So this case implicates both the 13th and the 14th Amendment. This was, I think, Jessica's question a couple minutes ago, right? There's overlap. There's a lot of overlap. And whenever you look at these cases, you have to think of both the 13th and the 14th Amendments. Okay? Again, so this wasn't a law about whether the states had to permit accommodations that are not segregated. This was about, again, Congress's enforcement powers under Section 2 of the 13th Amendment and Section 5 of the 14th Amendment. And so I want to start with the 14th Amendment, right? Is it Markia, you next? Okay, Markia, you want to give me, please, Justice Bradley. He gets around, Justice Bradley, right? He not a very significant justice, but he wrote a lot of really big opinions. It's just he gets around. So, Markia, you want to give me the majority opinion on the 14th Amendment, please?
Right, okay, so he's an idiot, but he basically
I'm sorry, what?
I said he's an idiot.
Okay.
So he held that the Civil Rights Act was, of 1875 was unconstitutional, and that based on the 14th Amendment, that only gives Congress the power to enact legislation that can be correct state laws.
Okay.
And that it basically doesn't give Congress the right to legislate affirmatively.
Okay, very good. So think of it this way, right? Generally, states have a police power. And that's a theme I will keep coming back to throughout the class today, right? States have a police power. Part of that police power is that they can regulate their corporations, their businesses. They can provide workplace conditions. At common law, there was a concept known as a common carrier. Did you do this maybe in torts, perhaps? Right? The idea of a common carrier is this. the state gives them virtually a monopoly, right? That they have a certain right that they have to accept any business that comes in the door, right? That's the basis of common carriers. I've researched this. I think there's a pretty good claim that under the common law, segregation was invalid, but I'm going to put that aside for a minute. Congress came in and they enacted the Civil Rights Act of '75, and it says, all persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters and other places of public amusement, subject only to the conditions and limitations established by law, and applicable alike to citizens of every race and color, regardless of any previous condition of servitude. Okay, and Section 2 continues, any person who violates the foregoing section that denies access based on race can be fined $500 or go to jail for not less than 30 days or more than a year. So basically a misdemeanor. Okay? Now, the question is, what gives Congress the power to enact the statute? That does two things. First, it supplants state law. It preempts state law. By virtue of this action, the states no longer have the police power to segregate their facilities. Right? Keep this in mind. A lot of these states actually had laws that required segregation. Like in Plessy, right? In Plessy, it was a state law that mandated segregated rail cars. Likewise, in some states, it said theaters must be segregated. Inns must be segregated. Hotels, restaurants, whatever, right? Jim Crow wasn't just about private businesses imposing segregation. It also included state-mandated segregation. That was an important part. So what makes this case difficult, right, isn't just whether these private businesses decide to exclude black customers. It's whether the state that licensed these corporations mandated segregation. Everyone just see where I'm going with this, right? So one of the difficulties is there actually state action? And I think Justice Harlan and Bradley actually have a very big disagreement on this exact point. But Justice Bradley says to the majority, the 14th Amendment is limited only to state action. These are private businesses. Therefore, Congress cannot regulate them. So let's take a look at the text, right? We have the 14th Amendment. Okay? So Section 1's not, so we start with privilege of immunity. It says, no state shall make or enforce a law that bridges privilege of immunity. Okay. Private entities can't make laws. I think we all agree that only government can make laws. We agree on that much, right? So at least the privileges or immunities clause applies to state action. I'll give you that. Then it says, nor shall any state deprive a person of life, liberty, or property without the due process of law. Again, that refers to the state taking your stuff away, right? I'll give you due process. I'm sorry, I give you state action. But then we get to the last one. And the Equal Protection Clause operates in a way that's not obvious. Okay? It says, nor shall any state deny to any person the equal protection of the laws. Okay? The Equal Protection Clause operates differently. It doesn't impose limitations on enacting legislation. It doesn't control how courts manage their affairs. The phrase equal protection was originally understood to mean equal enforcement of the law. This is an important point. It meant equal enforcement of the law. Okay? And so this would prevent a law that says facilities must be segregated. Right? So some states had laws that say you need to have segregated theaters, for example. Right? In that case, the law is not being enforced equally. But it also understood laws concerning state inaction. And what do I mean by this? Right? The states had an affirmative duty an affirmative duty to enforce the rights of all people, black and white, male and female. The government had to protect, and that's a key word here, protect them from both governmental and private deprivations of their rights. All right, so here's the key point. Even if private entities were depriving people of certain rights, for example, using common carriers, the government had to protect them from that. This provision was designed to ensure equality, and the state could have to protect that. And if the state failed to protect that, then that activates Section 5. Then Congress steps in, and they can throw in jail the people who are not doing this. Right? Congress can authorize lawsuits against the government officials, and they can even authorize, perhaps, criminal litigation against the person depriving you of rights. The court, though, rejected this reading. This is Harlan, I think, reading in the dissent, right? But the court rejected this. They said, no, it only refers to active state action. Now, let me take a step back. Lucian. So the court says Congress can only legislate on state action. Right? Fast forward to our last case, Plessy. Was there state action in Plessy?
Yes.
What was the state action in Plessy, Lucian?
It was a police power to the train cars.
Specifically, what was the state action in Plessy? What did the state do there?
Switch cases on me.
I know I did. Well, what? You take a minute. Jeremy, you know?
I'm sorry, ask the question. I just completely went blank. I'm so sorry.
What was the state action in Plessy?
The state action with them separating the state law that required them to have
Yes. State law that required the segregated rail cars. Everyone understand, right? So wait a minute, hold on. I know I'm jumping ahead, but there's a point. The entire upshot of civil rights cases is that Congress can't legislate against private businesses. Congress can only legislate against state action. And let's go back to the Civil Rights Act. It says, right? You can't segregate on public conveyances, like a train, for example. Wait a minute. So Congress says you can't have state action that segregates public conveyances. Everyone with me, right? Go to Plessy some years later. You have a state law that segregates on public conveyances. So here's the million-dollar question, which I didn't even think of until about a year ago. Why didn't the Louisiana segregation statute, forget the 14th Amendment, why did not the Louisiana segregation statute violate the Civil Rights Act of 75? Anyone? Question for the bunch. Again, if the Civil Rights Act of 1875 said you can't segregate in public conveyances on the basis of race, then why didn't the Louisiana statute run afoul, preempted by this federal law?
Maybe because it was strictly within the state?
Actually, no. The fact that interstate doesn't matter, but they actually had interstate rail cars.
Was it because the Civil Rights Act of 1875 at the time wasn't even enforced?
And what was one time?
Does that have to do with the, in Plessy, it was like a privately owned?
But it was a state law. That's why I asked the question, Lucian, right? It was a state law that mandated segregation. Michelle?
Is it that the Civil Rights Act is referring to person versus person instead of?
No. Yeah, am I?
Was it because the state can justify that it's separation but equal?
No. But the statute's specific, right? We don't know what the 14th Amendment means, but the statute says very clearly, if you segregate, you're going to jail. The court, yeah. I'm not going to give you more hints. If I give more hints, you'll get it. Sergio?
I mean, they didn't even mention the act.
No, they didn't. Why did Plessy not even mention the Civil Rights Act of 75? They actually did in the part edited of your book. It'll be in the next edition, but I'm giving you a preview. Mia?
Is it because they think that separation of people is a police power?
No, but the federal statute. Why is it? Plessy segregation law. Yeah.
Because separation, they held in Plessy v. Ferguson that separation did not imply inferiority.
You're right under the 14th Amendment. My question is on the statute. Markia?
It was like right there at being unconstitutional.
No, this is not about the. My question here is not about the Constitution. Why was not Louisiana's segregation law preempted by the Civil Rights Act of 1875? Federal law, supreme law of the land. Why is it not preempted?
It's just because they didn't
No, there's a better reason. There's a better reason. Good guess.
I mean, I don't know if that's right, but I was thinking commerce.
Nothing with commerce. Oh, you're gonna hate yourself once I tell you this. I'll give you one more guess. Anyone else want to guess? You're gonna hate yourselves in 5 seconds.
Wait.
Who's next?
Did it have anything to do with the Louisiana Purchase?
No, that's a good guess though. Very creative. James, what was the holding of the civil rights cases? The holding of the civil rights cases. The holding.
That basically the federal court could give redress for, it could give redress, but it couldn't affect state legislation.
No. James, what was the holding of the Civil Rights Act of civil cases? What was the holding of the civil rights cases? Did all those segregating theater owners go to jail?
No.
So what was the holding of the civil rights cases? And what was the holding? What actually happened to the Civil Rights Act of 75? Oh. Okay, so now it gets funny, right? I think, Sam, you said it. Say it again, please.
They said the Civil Rights Act of 1875 was unconstitutional.
Why did they say it was unconstitutional?
Because it violated they didn't have the power to correct,
Because there was no state action, right? Now check this. Follow me here. The court said the Civil Rights Act of 75 was unconstitutional because there was no state action. But we just said in Plessy there was state action. Well, I'm blowing your minds, right? How can they declare the statute unconstitutional in all regards, whether there's state action or not? Everyone see where I'm going with this, right? I read an article last year, blew my mind, by Jonathan Mitchell, The Writ of Erasure Fallacy. And he makes this case very compelling. The statute in Plessy violated the Civil Rights Act of 75. To the extent the court said the Act of 75 was unconstitutional, it was only where there was no state action. Do you understand what I'm saying, right? They said where there's no state action, Congress cannot intervene. But where there is state action, Congress can intervene. So when you have a state law, I'll get to you in a minute. When you have a state law that mandates segregation in public conveyances, that law still runs afoul of the Civil Rights Act of 75. Now, here's what blows your mind. We often say courts strike laws down. I say it all the time. I shouldn't say it. Courts do no such thing. Right? They don't have an eraser. They can't erase a statute from a book. In the civil rights cases, the court cannot wipe the 75 Act from existence. All they can say is it can't be enforced in this case because there's no state action. Right or wrong, you can argue, that's all they can do. But they did not say what happens when there is state action. So actually, in Plessy, they do mention the Act of 75. It's not in your book, but it'll be in the next edition. They say, well, the Act of 75 doesn't apply because we declared it unconstitutional in the civil rights cases. Wrong. They only declared it unconstitutional when there was no state action. But in Plessy, there was state action. So Plessy, I think, is wrong on that front alone. Yeah. Jeremy and then Kyle.
I have to ask the obvious question. So basically, because of their misinterpretation of what the court previously defined as unconstitutional, separate but equal was allowed to stand for 80 years before.
Yeah. Congress passed a statute that said you can't have state laws that segregate. And the court basically ignored that in Plessy. This is new. I didn't have this last year. I read this article, it blew my mind. This is going to be in the next edition of your book, so I'm giving you like a preview. Yeah.
I don't know. It's just clear. I don't know who asked the question, but it is because they don't care, right?
Yeah, I think Yaron said that. Yeah. Well, maybe that's right. Maybe they just don't give a damn. But I'm giving you an actual legal answer, and then you can give the IDGF, whatever it is.
Yeah.
So the legal answer is they misinterpreted what they.
No, the legal answer is they misinterpreted the scope of their own decision. They said their decision impacts not only cases without state action, but the entire statute's void, where they only said the statute was unconstitutional in the absence of state action. So what happened is after the civil rights cases, Louisiana and states started enacting laws that mandated segregation, right? In the opera theater, it was voluntary, right? It was these private businesses wanted to do it on their own. But later, states began mandating segregation, right?
They thought they could get away with it.
Yeah, the trains, again, we'll do Plessy later, but the train companies didn't want this. They didn't want to deal with this crap, right? It's expensive, you have to have more cars, you have to have security, right? They didn't want to deal with it, but they were required by law to deal with it as a form of mandated segregation. So everyone get this, right? So I think Plessy could be wrong on a number of reasons, but I think it violates the Civil Rights Act of 75 just as the simplest reason of all. You don't have to get into separate but equal, the statute. Congress had the statutes on the books. It's still in the books today, right? This statute's still in the books today. It won't be enforced because people think that, oh, the statute's unconstitutional. It's still in the books. So if you have a state segregation law with their state action, then you can go to jail. Indicted. Go to jail for a year. How's that? Blowing your minds? Let me try. Yeah, again, I didn't know this one last year. This one's new to me. I told Randy he didn't know it either. So this one, we learn new stuff every year. Every year I teach this, I learn new things. It's one of the beauties of this job, always learning new stuff. From 100-year-old cases too. This case is 140 years old. I'm still learning new stuff about it. All right. So any other questions on the state action doctrine, right? The state action doctrine says that Congress cannot use its Section 5 powers unless there's state action. And in this case, these are private businesses. Therefore, there's no state action. That's the holding of the majority. And the state action doctrine is still good law. When we studied VAWA, right, the Violence Against Women Act case, Morrison, they said, well, domestic violence is not state action, therefore Congress can't intervene. So this doctrine has been reinforced a number of times. By the way, the VAWA case arguably is a very good equal protection case. If the states are not protecting people from violence, that potentially triggers Congress's Section 5 powers. Right? That takes the word protection literally. So I think Morrison could be decided on the other way, not just by Commerce Clause, but also Section 5. The court's Section 5 cases just it's a mess. Mess. All right. So questions in the majority in civil rights case. I'll do Harlan in a minute. Yeah, Andrew.
Early on this semester, one time I said that a law was struck down and was...
Did I yell at you?
Kind of.
Good. I do it myself, and I regret every time I do it.
Where we landed on it, though, was that the way that this practically works is the executive branch just starts enforcing it again.
Yeah.
And it goes back to the court system and retests.
Yeah, I mean, think of the legal tender case, right?
Right.
The court said paper money is unconstitutional. Then like a year and a half later, said, just kidding, now it's constitutional. Right, the statute didn't go anywhere. The statute was still in the books. They just said, just kidding, we have new members of the court, we come out a different way.
So any time between when the civil rights cases were decided and even today, you could just enforce that and try it again?
I don't know if there are any state statutes that fall run afoul of this, but I think the statute is still valid. I think it proves an important point that courts can't strike down legislation. In fact, for the 4th edition of your book, I did a Control F. Of every single time we said strike down, I just deleted it. I Control F the entire book. Invalidate, strike down. I took it. Randy's not going to like it, but I took out every single instance because I don't want to be consistent. Anyway, but yeah, good point. I almost fell. I've fallen. This is really stupid. I don't know why. Who thought this was a good idea? Where the professor's saying to have a step ladder. It's just a bad idea. These classrooms just are really poorly designed in general. Like this. I mean, look, I am 6'2". This basically hits my head every time. It's like duck. Anyway, bad design. Tall people problems, right? All right. Any other questions to the majority in civil rights cases? James, did you actually give an answer? I can't remember.
I answered one question.
Okay, so Justin, you're up. Did you just dodge?
No,
Okay.
that's cool.
Justin, you next?
Yes, I'm next.
All right, so let's talk about Harlan. And when we talk about Harlan, I want to talk about the 13th and the 14th Amendment, right? So, Justin, how does the majority construe the 13th Amendment?
That it focused on emancipating the slaves and nothing else.
Yeah.
And Harlan said that in freeing the slaves, that it also gave them all the rights that came along with being free.
Okay, very good. Thanks, Justin. There's a huge disagreement in, the 1870s, a decade after the 14th Amendment's ratified, about what these damn things mean. And we look at the 13th Amendment. It says neither slavery nor involuntary servitude shall exist within the United States. And just the text of that tells me that slavery and involuntary servitude are not the same thing, right? If they were the same thing, it's duplicative. It's, you don't say the same thing twice. So slavery has to have some meaning that's different than involuntary servitude. The majority in civil rights cases reads them as synonymous, that slavery only refers to physical servitude, okay? But they agree on this point that Congress has the power to eradicate what are called badges or incidents, or I would say reminders of slavery, right? That Congress can use its Section 2 powers to eradicate these badges or reminders of slavery. Andrew, what are these badges? What does that mean?
It's like reminders or incidents.
But specifically in the context of the segregation laws at issue, right? How would the segregation in these theaters amount to a badge of slavery?
On page 70, it talks about the fact that slavery was built on like the inferiority of the race,
Mm-hmm.
and that segregating theaters reminded people of that.
Yeah, I think that's right. So at least according to Harlan, again, he was only dissent, just one vote, but at least according to Harlan, the 13th Amendment wasn't only meant to eradicate physical involuntary servitude, chattel slavery. It was also meant to eradicate the institution and the reminders that you were once a slave and now you're free. It's very Passover-y, right? To eradicate these badges. And going to a restaurant or a theater, it means, I'm sorry, you can't enter here. You got to go this other door, right? Going to a train car, you got to go this other car. Was, at least according to Harlan, a badge that's literally affixed on a person. Think of Hester Prynne, Scarlet Letter, right? Scarlet A. It's a badge that's affixed to your person to remind you of what was once existing that is not supposed to exist anymore. And Harlan says Congress can use Section 2 to enact a statute. Now, why is Harlan making such a big fuss about Section 2? There's no state action requirement. The 14th Amendment uses the word state, 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 right? The 13th Amendment says it can't exist anywhere. That's pretty damn broad. It cannot exist within the United States. So the advantage of the 13th Amendment, at least for Harlan, is it doesn't have the state action requirement. It applies to both public and private conduct. Public and private conduct. Okay? Now, Sahar, how does the majority read the term slavery and badges of instances of slavery? How does the majority understand that term?
Subject that person to any form of servitude or fastening.
So, you use the word servitude. Does the majority limit slavery to just physical servitude? Is that how they define the term? Okay, let me ask you this question, Sarah. I'll ask it differently. For the majority, what sort of law would affix a person with a badge of slavery? What kind of law would actually do that, according to the majority? Right? In other words, what would actually run afoul of the majority's definition of a badge of slavery?
I'm not sure, but like maybe he didn't think that every act of discrimination would be, or he thought that applying the Civil Rights Act to every act of discrimination would be running the slavery argument into the ground, and mere discriminations on account of race or color were not regarded as.
Okay, very good. That's correct, okay? The court says every act of discrimination is not slavery. Right? That every mere act of state discrimination is not slavery. My question is a little bit different. What room exists in the majority's definition to actually have a badge of slavery, short of actual slavery? Or short of actual involuntary servitude, what would run afoul? Anyone? I don't know. Yeah, Mia?
Like for the majority?
Yeah.
They, like if a state passed a law that prevented black people to contract because of their race.
Do you think that would do it?
Yeah, because they said that, they said in their opinion that Congress would have the power to enact legislation that was necessary and proper for the obliteration and prevention of slavery with all its badges and incidents. And then they listed what the incidents were. And they were saying those fundamental rights that were the essence of citizenship. They did say that mere discrimination within race was not a badge of slavery, but that would fall under the list of like the ability to contract.
What a good bridge to the next case, actually.
Or like, I guess they also said to be a witness in court.
Yeah. So, Brooke, you want to add something?
They also mentioned taking a property without due process.
So like the Civil Rights Act of 65, right? Remember we discussed this class last week? So the majority, I think, reads badges in a fairly narrow fashion. Harlan would read it much more broadly. But the upshot is, and this is summing up civil rights cases, you don't get the 14th Amendment, Section 5, there's no state action. You don't get 13th Amendment Section 2 powers because this is not a badge of slavery. Therefore, Congress cannot prosecute people who enforce segregation in their businesses. Again, this didn't discuss where there was state action, like in Plessy. The entire premise of the civil rights case Plessy thing is off, right? But the court says here we're declaring a statute unconstitutional. They didn't consider if there was state action with a state segregation law.
So I missed how you said the majority defines badges of slavery, if they define it.
Very narrowly, right? It's not, Harlan will say things that remind you of slavery, bring back inequality. The majority says to deprive you of very specific rights, which Mia listed a moment ago, that are based on race. But I'm hesitant to even do that because the court doesn't really mean it. Because there are a hell of a lot of laws that actually deprive people of their rights on the basis of skin color that were simply upheld. So, yeah, so I don't, Mia read correctly what that said, but it didn't have much weight. Get to separate but equal, and you see what happens. All right, so any other questions on civil rights cases? Very important decision. All right, the next case, Yickwo versus Hopkins, is a very, it doesn't fit, right? And this case always was difficult for me to teach because, like, wait a minute, how do you go from, Yickwo v. Hopkins in, 1886, and then a decade later you get Plessy in 1896, right? And every year, students would ask me, Josh, how do you bridge these cases? And I actually did something, I did something with Strouder. I read the entire case, right? Not the edited version in your book, but went back and read the entire case. And there's a lot of stuff there that shaped how I think about this decision. So I teach it differently now than I did a couple years ago. All right, who's next? Austin, I think you're next. Austin, you want to give me the facts, please, in Yickwo v. Hopkins?
So in 1880, San Francisco passed an ordinance, and they made a crime to operate laundry in a wooden building without a permit.
Okay. And why would they require special restrictions for operating a wooden laundry in a wood building? What? Just as a.
I think probably fires.
Yeah, I mean, you have these huge boiling cauldrons of water, right? Really hot water. You have embers, you have wood. You may not have good ventilation, a wood building. Okay, that makes a little sense. All right, so go on.
So they said about 95% of the laundries were already like that, were in wooden buildings.
Okay.
And so, these owners had to apply for the permit.
Okay.
And most of the building owners, they got the permit, except there was it seemed like only Chinese owners weren't allowed to get a permit.
So, Austin, let me ask you a question. What did you have to do to get a permit? What was like the standard to get a permit? You have to show that you had proper ventilation, or maybe that you had, fire extinguishing equipment, or you had to have clean equipment.
No, it wasn't very strict. I think an inspector just had to come by. They didn't have to show all that equipment.
Was there any what was the standard you had to meet to get a permit?
There wasn't a standard.
He's right. It was arbitrary, right? You had to apply for a permit, and it could be granted for any reason at all or no reason at all. There was no standard whatsoever. Now, his name wasn't actually Yik-Wo, it was Lee Yik. It was spelled wrong in the reporter and stuck. Yeah, but the guy's name was Lee Yik, and he had operated a laundry for a number of years. And in fact, he had been given a permit by the city in the past. They inspect his equipment, everything looked fine. He had no violations, he had no problems, everything looked to be okay with his business. He applied then for renewal of his permit, and it was denied. There was no reason given for the denial. They didn't say, okay, if you do this, 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 you get your permit, bring up to spec. They just denied his permit outright. All right, carry on. Yeah, you're up next anyway. So, Brooke, let me ask you a question. What happened to Mr. Lee Yik? When he didn't get his permit? Did he shut down his business?
Oh, no, he didn't.
Well, specifically, what happened to him?
Oh, he was convicted.
He was thrown in jail, right? And again, I just want you to understand this. This wasn't like a civil fine. The guy was thrown in prison, right? Hopkins was a sheriff, right? This was actually what's called a habeas corpus proceeding, like Merriman, right? Where he challenged his confinement in court. And he argued that the state conviction was a violation of the 14th Amendment. So, Brooke, what happened?
Well, the majority, ironically in this case, started by saying that they're dividing the owners or occupiers into two classes, not having respect for their personal character or qualifications, but merely an arbitrary line on those who are permitted to pursue. And the conditions, there, like you said, there were no specific conditions, but they talked about the 14th Amendment and says that there should be protection for the citizens and the state should not deprive them without due process.
Okay, very good. So this case is difficult to teach because it's a bit of a jumble, right? I think Jessica asked me this question before, which clause are we talking about? It's all jumbled together. The court discusses due process. The court discusses equal protection. There's also a treaty implicated, which I don't know how much that even matters to you. But the United States and China had signed a number of treaties. And one of the treaties protected Chinese laborers who would go to the United States. So what you actually had was a state prosecution depriving these Chinese laborers of rights secured under international law. So there was a lot of reasons why the court did what they did. Now, Brooke said ironically. Why'd you say ironically?
Well, because, on the previous cases, there were arguments made against the fact that the Congress didn't have the authority. And they didn't see the distinctions that were harmful. But in this case, they talk about an equal eye and an equal hand. And so it was unjust and illegal discrimination. So it's almost like the interpretation of the Constitution is not very consistent. And so it's ironic that now in this case, they do see the equal eye and unequal hand as it relates to the arbitrary deprivation of rights.
Yeah, very good. And I think she made the observation that basically everyone observes when they read these two cases back to back, right? In the civil rights cases, they read very narrowly Congress's Section 5 powers of the 14th Amendment and the Section 2 powers. But here, they are very much inclined to serve as a censor of the state legislation. Now, let me walk you through his opinion one step at a time. Again, it's very jumbled, and I only unpacked it myself a couple months ago. I had never read the entire. I was on a C-SPAN. C-SPAN has a show called Landmark Series or Landmark Cases, and I was on it last year. I did an episode on Yik Wo, so I really dived deep into this case. So if you want to watch it, it's on my YouTube. But it's like an hour-long show on Yik Wo. Really good. I was with a professor from Columbia, and she teaches Asian American history. Really, really bright professor. And we just talked about it. We actually took callers. These people are nuts. If people call it the C-SPAN, they're generally pretty crazy. Just ignore the calls. But we had a really good discussion. It's like, hello, caller, right? Whatever. Public service. But I want to walk through this one step at a time, right? So first off, these individuals were not citizens. And that does make a difference. They weren't citizens. Therefore, the privileges or immunities clause doesn't really help them out because it only affects citizens of the United States. All right? Lee Yik was not a citizen. He was a laborer here by virtue of one of the treaties with China. Okay? But we have two clauses that apply not just to citizens, but to persons. We have the Due Process Clause and the Equal Protection Clause. And the court says that these provisions are universal in their application to all persons within the jurisdiction without regard to any differences of race, color, or nationality. And the equal protection of the laws is a pledge of the protection of equal laws. Okay? So the first provision I want to talk about is the Due Process Clause. This is a preview of what we're going to be doing in about a week or so after the midterm. But in the early 20th century, the progressive era, the Supreme Court interpreted the Due Process Clause in a way to protect what we would probably today call a liberty of contract or right to carry out your trade. The same right that the butchers asserted in Slaughterhouse under privileges or immunities shifted to the Due Process Clause. And the argument was your right to earn your trade was a liberty and property, and the government could not deprive that from you without giving you certain due process of law. So the court actually here has a flavor of this liberty of contract, right? Think of the butchers in Slaughterhouse. What do they argue? By shutting down my business and making me go to this other facility, you're depriving me of my contract rights. Ring a bell? What's going on here? That if you don't have a wooden structure, a non-wooden structure, you got to shut down your business. Right? Your business was lawful, it's safe, but you got to shut down your business. So they actually argue that this was depriving them of their property and perhaps liberty without the due process of law. And the court says that this fundamental rights to liberty and pursuit of happiness include possession of property, individual possessions. And then they attack the standard, right? What process was given to Lee Yik when they took away his permit? Zero. The court says that no reason whatever except the will of the supervisor is assigned why they should not be permitted to carry on their custom manner, their harmless and useful occupation for which they depend on the livelihood. This is basically the argument of the butchers in Slaughterhouse. It's very similar, right? The court continues that no man should be compelled to hold his life or the means of living, his livelihood, on the mere will of another. Right? You should be able to work without having arbitrary restrictions. They say that that law is not consistent with the due process of law. It's a naked and arbitrary power to give or withhold consent. Okay? So that's why the law violates the due process clause. And most case books just ignore that, and I think it's a mistake. But then you get to the equal protection clause, and this is Brooks' irony point that I think most people start like screaming out loud about, right? So Sam, they say, let me read this quote, very famous quote. Though the law itself be fair in its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discrimination between persons in similar circumstances, material to their rights, the denial of equal justice is still within the prohibition of the Constitution. What is that? I just read that very famous passage, which is cited a lot today. It's the only passage we'll cite from this case. What does that mean?
Even though the law is not a violation of the equal protection, if they carry out that law where it is a violation, like an evil hand, evil eye of the equal protection clause.
What's an evil hand, evil eye, and equal hand? What does that mean, Sam?
To me, it means you're not looking at basically solely on the facts. You're looking at something evil, more sinister.
How is a court to know what an evil eye is?
It would be their interpretation.
How's a court to know this? If you're looking at a statute, right? The statute says nothing about race. It says you have to have no wooden structures for a permit. That's all the statute says. Sam, how is a court to know that a statute that is facially neutral, the statute makes no reference to race, has this evil eye? How's the court to know that?
Because it just allows them to reject this person for no reason at all. Even if they met all the requirements, we say we're still going to reject you.
But is that evil? What about it makes it evil?
It's not fair.
Not fair. Cassandra, what about, how's the court know there's an evil eye here?
I think
You dropped a coin.
it would be more like people can use it in a bad way or see it in a bad way or.
But how does a court know there's an evil eye here?
I think they knew that they made the law for it to look and see, well, it was equal, but they manipulated it and.
How do they know that, though? What evidence does a court have of that fact? What are the facts? You tell me.
The facts were that they denied the 200 Chinese descent, but they allowed the 80.
Yeah. So the court says, look, we're not idiots here, right? We look at the statute. All the white people got their permits and the Asian guys didn't. That is the evidence of the evil eye. That it has an impact on a disproportionate group, which was the Chinese laborers. Right? It didn't apply in the same fashion. But I just want to take a step back here and just think about this a little bit differently, right? The reason why this was a facially neutral statute is it gave the government unlimited discretion. And this is an important point. When a government official has the power to deny you a license for any reason or no reason at all, that is often a cover for an ulterior motivation. That's what they talk about the evil hand, right? If the statute said, you will get a permit if you have, I don't know, good ventilation, fire extinguisher, name 5 things, right? If there are specific criteria to get the permit, then it's a lot harder to be racist about it, right? You can still do it, I'm sure. But it's hard to say, look, I did these 5 things, why are you denying the permit? But when it's unbridled discretion, when it's completely arbitrary, that allows people to say, well, we're denying the permit because we don't think it's good, but no reason is given. So the court bundles that together. They say, look, when you have this unbridled discretion, it allows someone with an evil eye to discriminate. So even though the statute's facially neutral, this discretion without any standards is arbitrary. And this arbitrary standard deprives people of the equal protection of the laws. The court says the facts shown establish an administration directed so exclusively against a particular class of persons as to warrant and require the conclusion that the government's mind was so unequal and oppressive as to amount to a practical denial of the state of the equal protection of the laws. Right? The hostility to the race and nationality of the petitioners. Therefore, it was illegal and violated the 14th Amendment. Was this law designed to promote the police power? The court says it was not. That there was no justified basis to impose this law. You know, maybe it was true that wooden buildings were really a threat. Maybe that was true. But the court didn't justify why. And this is something new. We haven't seen this before in a case, at least majority opinion. When you have an exercise of the police power in the late 1800s, early 1900s, the courts ask, why are you doing this? Right? What is your justification for this rule? If you can't give us a justification, that means you probably have some other motivation. I say it again. If the government can't give you a justification for why they have this rule, there's probably some other motivation that's improper. And the court says, we're not going to let you just fly by night. You got to give us a good reason. If you give us a good reason, that's fine. That is not how courts look at things today. Today, courts are much more deferential for police power stuff. But in the late 1800s, early 1900s, they started being skeptical of the state police power in light of the 14th Amendment. Okay. Right, so the upshot of Yick-Wo, you think, is this broad principle that courts can set aside police power legislation that has arbitrary standards and denies people equal application or equal protection of the laws. Seems great, right? Then you got 10 years later, and you get to Plessy. It's like, whoa, what just happened, right? How do you line up 1896, 1886? How do you line those up? Okay. So any questions on Yick-Wo v. Hopkins? Yeah, go watch the C-SPAN special if you have lots of free time. But just, instead of Netflixing, just watch it. You'll learn a lot. I thought it was very well done. Except the callers are nuts, though. Just ignore the callers. This one guy called in. He was insane. I don't know what he was saying, but I was like, go away. Yeah, Carrie.
So specifically in this case, so they enacted the statute just to take the property away from the Chinese. So I think when I first read this, I thought it was that they put the statute in place, of course, for safety purposes, and then those kind of took advantage of.
Well, right, but if it was for safety purposes, wouldn't they say if you have proper conditions, you can keep your shop, right? Mm-hmm. This wasn't just saying. This was like Slaughter saying, basically, if you have a wooden floor, you shut down. And at the time, what was it, 90% were all wooden buildings. And then they randomly said, okay, we'll give you people permits to operate in wooden buildings, but no one else. And all the guys they gave it to were white. So the court looked at how the statute was being enforced. In other words, this was just a cover for what they actually wanted to accomplish, which was to remove the livelihood of the immigrant workers, which was to reduce competition. It's nothing new. Yeah, Elia?
I'm kind of going through something like this personally. I manage two properties, two Airbnb properties in Las Vegas, and I just received an email that the city is trying to shut down Airbnb.
I saw that.
And now I'm thinking, what about my equal protection?
Yick-Wo. Yeah, so a lot of everyone know what Airbnb is? It's you can basically rent a room for like a day-by-day basis, right? A lot of cities are trying to shut down Airbnb because they compete with hotels. And Las Vegas is a huge hotel city, right? So I can go pay, the MGM Grand $400 a night, or I can pay you, how much do you charge a night?
200.
200, right? Yeah, basically half, right, for a nice room?
It's a whole house with a pool.
That's nice. Wow. So if you get a room for 400 or a house for 200, right? I'll give her a call, right? I was in Vegas last week. I did a lecture there. I saw Britney Spears was there. It was a good show. It's a really good show.
I said you gotta see J-Lo. She's right.
Oh, she's done. She's not doing that.
Is she done? Well, okay. Anyway, but we'll study economic liberty, and under modern doctrine, the courts have actually held that the state can enact a law to protect businesses. that a rational basis to justify a police power is to protect the local businesses. So if Las Vegas said, you know what, we're going to shut down Airbnb to help the MGM Grand out, that'd actually be a valid law. But they'll say, we don't trust that Ellie is giving enough safety and she's not treating her patrons well, and that we want to have registration and security and all this blah, 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 right? So generally, the court can just look and say, well, health and safety is fine. So you might lose your business. I mean, Vegas tried shutting down Uber as well. That eventually didn't work out so well. And a number of cities have shut down Uber along similar grounds. They did for a while on security grounds. I mean, they said because Uber drivers weren't safe. Maybe they're not. I don't know. I've actually stopped driving. I Uber everywhere. I basically given up in the car.
Oh, first I thought you were saying you were an Uber driver.
No, the opposite. I'm an Uber passenger. I don't ever drive anywhere anymore. It changes your life. If you can work in the backseat of an Uber, you get like hours every week of new time, productivity, hours.
Unless you get sick riding in a car.
No, I'm fine driving. I'm sorry? Yeah, I mean, you can basically, I've put in the last year like maybe a couple hundred miles on my car, and I've it paid off, so it just sits there in the garage. Save gas. I mean, the big thing is time, though. You get a lot of free time to write, which is what I do. All right. So any other questions on Yikwel before we go into the last case, Plessy?
I do.
Yeah, Mia.
So, because the law was applied by public authorities, the city ordinance was applied by public authorities, that's how they said that they were representing the state?
Yeah, there's absolutely state action, no question. It's a state law. Right? It's a municipal law, but it's under the umbrella of the states. Cities only exist by virtue of the state. So when a city passes a law, it's basically the state passing the law by delegation. All right, so any other questions, Yikwel? All right, I think Yaron, you're next. Give me, please, the facts in Plessy versus Ferguson.
So, the state of Louisiana, of the General Assembly of the State of Louisiana passed in 1890.
Yeah.
And basically, they segregated all the railways.
Uh-huh.
So they had separate for white and color. All the railways had to provide separate but equal, the statute says. This included different coaches and also a partition to basically secure the division of the people. And then the second provision of it, the second section of it, was that the officers of the passengers of the train had the power to assign the passengers to where they were supposed to be. And anybody who didn't want to comply had to be penalized either $25 or imprisoned.
Yeah.
But for not more than a period of 20 days, they said.
Okay.
The third section of this act basically stated that any officer who failed to do this would get penalized. And there was, the only exception that they had was, and they said, nothing in this act shall be construed as applying to nurses attending to children of the other race.
Wet nurses, basically. Yeah. But there were actually, we'll do another case later called Buchanan against Worley, where it involved a law saying that if you were white, you couldn't buy a house on a black block, and if you're black, you couldn't buy a house on a white block, but there were carve-outs for servants that they could live amongst. So this actually is fairly common that there were carve-outs. Yeah. So this was actually state-sponsored segregation, right? In civil rights cases, you had private businesses that segregated. In Yikwel, you had a statute that looked neutral, but as applied was not equal. Here, they said, F it, right? And they just made a straight up racial segregation. Like there's no, you see the progression, right? Right? It just built up to saying, whatever, we're going to just straight up exclude people on train cars. Again, I reiterate the point that this was a violation of the Civil Rights Act of '75, but that is a hill that I will not win. By the way, I think, who sent me pictures of this? Was it you? Yeah. So you went to the cemetery where he's buried? Yeah. Where was it?
In New Orleans, it's the cemetery. It's like a historical cemetery, and I was there a few months ago. It's really nice.
Yeah, I've never been. I do want to visit it. There are a lot of pictures floating the internet that are of Homer Plessy. They're not him. We actually don't have any photographs of the guy. We just don't know what he looks like. I found pictures like, oh, this is Homer. Like, I can't verify that that's the guy, so I don't know. We do have pictures of his grave. I have a picture of his birth certificate, which is in the Orleans parish.
And they had to replace his tomb because people, I guess someone
Defaced it?
vandalized it.
That's a shame.
There's a bunch of different tombs that they vandalized, so they replaced it, and it's really nice.
That's right. I will go check when I'm in New Orleans. Go visit the slaughterhouse and go visit Plessy's tomb. Thank you for that. Appreciate that. So we have Homer Plessy, right? This is what we call a test case, right? What do I mean by a test case? The guy wanted to get arrested, right? He was there deliberately to try to challenge the law. And the facts were such that he got on the train deliberately. They told him, you need to get up and go. He said, no way. And then he got arrested. He was held on a $500 bond, which was posted. Now, generally people didn't, that was a lot of money back then, $500. And people didn't usually have that lying around. So basically they were waiting to bail the guy out. That's what this was. They bailed him out. Now, why is it Plessy against Ferguson? John Ferguson was the judge. And it was some weird wrinkle of Louisiana law, which I don't fully understand, that when you're challenging your sentence, you actually sue the judge. It's a weird thing, but yeah, I don't know. But anyway, so John Ferguson was the judge who sentenced Plessy. I actually found, this is another picture of him, he looks a bit younger in age, but I actually found his obituary from the Times-Picayune, which was the leading newspaper of the day. And can you imagine you write the decision, that's your case, and didn't even mention the case, right? That's like your most famous thing in the world, and didn't even mention Plessy. Whatever. Okay. The newspaper had this account, which you can read. I won't recount it for you, but it basically describes him as the that's what I wanted to show you. Where is it? A snuff-colored descendant of Ham. So was that you, Kenesha, who asked me about this, about the biblical origins of slavery? Someone asked me about that. Was it?
No, it wasn't me.
It came up, right? And I think I mentioned Ham. I mentioned this, right? So they actually, again, there was a strong biblical component of segregation. And they describe him as a snuff-colored descendant of Ham. Ham was the son of Noah, who was darker.
She said that there was Adam and Eve.
Yeah.
I didn't say that.
No, I think I did. Okay, very good. Okay. So that's how they describe him in the public newspaper, all right? So the case goes to the Supreme Court, and once again, the vote was 8-1. Carrie, so describe the majority opinion for me, please.
So they basically said that it didn't violate the 13th Amendment.
Okay, why?
It basically, that's only about slavery.
Now let me just pause you here, right? I think Mia made this point a few minutes ago. When you talk about the badges of slavery, how is straight up segregation, does the court say it's not a badge of slavery? What's the answer there?
I think they started mentioning that even though the two races are different, it doesn't just mean that it's an enactment of slavery. Just because they're two different races doesn't mean that it automatically goes as a badge.
Okay.
And I think they even made, I don't remember where, but I think they even made a comment that if they're thinking that, then that's on them. Something in that sense.
Yeah, Daniel, let me follow up on you with this, right? So this is a police power law, right? Why does Louisiana what's Louisiana's justification, the defense of why they need this law?
Race relations.
Give me a little bit more.
Make sure that both sets of individuals are protected and they're not in a situation where there's going to be a fight, anything like that. And then they mentioned that if the two races want to cohabitate, that they need to do that on their own.
Okay, very good. So the court here has a lengthy discussion of the police power, which is worthwhile mentioning, right? They say that laws requiring the separation is within the state's police power. They say there are limits. The state power must be exercised in a reasonable fashion and must be enacted in good faith for the promotion of the public good and not for the annoyance of oppression of a particular class. Okay, now again, we have Yik Wo decided not even a decade earlier, where they say, was this law enacted to prevent fires? No, it was not, because all the burdens fell on one class, the Chinese laborers. So I'm almost done, okay? Here they say, is this a reasonable regulation that's within the discretion of the government? They say it was reasonable in light of the established usages, customs, traditions of the people, and with a view to the promotion of their comfort and preservation of public peace and good order. Yeah, Kenesha?
Right. So I have a question, and unfortunately I can't ask these people who are unfortunately dead. How exactly do you justify that there's this separation that will keep the peace, and that interracial marriages and things are illegal, and these are the same people that were having sex with their slave females, and that's how you had an interracial child, because it was a white and a black, yet you outlaw the very thing that you've done. So clearly people are idiots. You're doing exactly what you said is right. I don't see how you don't see that in these.
I think you make a very fair point.
There are interracial children today, so it's an accurate point, right?
Yeah. Let me ask the question this way. I think, Adrian, I think you're next. I'm sorry. Sorry, there's a huge gap right there. What was Louisiana's justification for why they needed this law? What did they argue was necessary to have this law?
Okay, I thought you just said when they talked about the distinctions between.
In other words, Adrian, did Louisiana enact this law because they said that the races are inferior and superior? Is that why they enacted this law, according to them? Did Louisiana say, we need this law to promote the inferiority of the races? What'd they say? What'd they say there was a reason why they needed this law?
I thought it was I thought you just explained it in power that they thought it was necessary to maintain like safety.
Okay, good. Why? What exactly were they concerned about if the races were mingled on the trains?
I think they were probably most concerned with unrest.
Yeah.
Social unrest.
Violence. Yeah.
From whom?
From whom?
You know this is just perfect.
No, but actually you're going exactly where I want. Who was at risk of the violence? Yes. The African.
The superior race was the one that was,
So I want to just make this point. Kenesha actually stole my thunder. You stole my thunder. But she made the correct point. They were saying that if the races are mingled, the white people go beat up the black people. We can't have that sort of violence in the train. This is for the protection of the black customers.
Isn't that what Harlan was saying? Like if they want to protect, if they're willing to undertake that, that's their right. Like
the forced segregation, they said, was for the benefit. In fact, when we get to Brown, right, and we do Cooper against Aaron and Little Rock, the government's justification for segregation was to protect the black students from violence. It's for what?
It's because you fear what you don't know.
Oh, I like the way you phrased that. So the argument here was they needed to do this to protect the black customers from violence on the rails. And they said if people want to commingle, they can commingle on their own, but they can't. Because they couldn't commingle if they wanted to. Again, the trains didn't want this. This is history, right? The railroads didn't want this law. They didn't want to deal with this. They just didn't want this at all, but it was forced upon them. That's what I hand somewhere.
so then if that's the case, then why would they arrest blacks instead of
Exactly.
Be able to sit in a colored car and would not be arrested.
Which is why the law, the motivation given wasn't the actual motivation, right? The reason why these laws existed was, just one at a time, guys, just one at a time, please. The reason why these laws were enacted was to promote the inferiority of races. That's what this was designed to do. It was designed to make a public, open, outward manifestation from the youngest of ages that one race goes here and the other race goes there. Right? Segregated schools were the same, to teach people from the youngest of ages. One race goes here, the other race goes there. You can't mingle. That Jim Crow was designed to prevent the mingling in any forum where people existed. It was a partnership of both public and private segregation. Right? And the court says here that that was a reasonable usage to preserve public peace and good order. There's no evidence to that fact.
There's no evidence that the white people wanted to go see the tuberculosis, so that's not
No, none.
So, are you saying, Kanisha, that they wouldn't wanna go and sit in the other car with the, I thought I heard something about arresting, I don't know, they didn't go to it. But according to the statute, they would have been arrested and found.
Yeah, and so that's why it's a facially neutral statute in theory, that the whites can't sit in the black car and the blacks can't sit in the white car. But we all know how the statute was being enforced. I'm sorry?
Evil eye.
And I think, yeah, it's being enforced with the evil eye deliberately. This is why Homer Plessy was arrested, quite deliberately. Right? And this gave birth to the doctrine which most people are familiar with, is it says equal but separate, but it kind of got flipped over time to separate but equal, which I think sounds a little bit easier to say. That as long as the accommodations are separated and they provide equal access, they're fine. And this gave rise to segregated schools, segregated rails, segregated virtually every single government institution.
If it was equal, how come they didn't wanna go?
Oh, it wasn't equal.
If it was equal, why wouldn't you come sit in the back with me and come go to school with my child, if it's so equal?
Wasn't
You
equal.
don't want to.
Wasn't equal. Brooke.
Yes, so I was reading, and it was very interesting. It said, on page 887 about the 13th Amendment and, its abolishment of slavery, but that it equally forbade Mexican damage and Chinese food trade, and the amount of slavery are involuntary. So I guess that was just so interesting to me.
Well, let's talk about it. I'll get to Harlan with the Chinese stuff. I'll get to Harlan in a minute. That's what it was like. Go Harlan, what? Right? It's like. No, there's a majority. Yeah. But I'll get to that. I'll get to that in a minute. I promise. We're running a little bit short on time, but I will get to that. I promise. Justice Brown says that the 14th Amendment was never intended to abolish distinctions based on color, or to enforce a commingling of the races upon terms unsatisfactory to either. Again, the law didn't permit the commingling because it forced this common carrier train to separate them. And they say the separation of the two races in public conveyances is no more obnoxious to the 14th Amendment than acts of Congress requiring separate schools for colored children in D.C. And at the time, the federal government did segregate schools in the District of Columbia. We'll come back to that when we do Brown, I think, after the midterm. Okay? So when we get to Harlan, I have a couple minutes left. So we get to Justice Harlan. Yeah.
One thing I saw is that I kind of just keep getting a common theme. So kind of like going back to Dred Scott and then going to this case, I just feel like, this is kind of the same thing where it was like, hey, we know it's just kind of flipped on its head, like, whoa, how did we get here? Pretty much, we don't care what the president was of Yick Woo, we're just gonna go in another direction. But I just feel like every time we get a case like this, we start seeing, it's kind of like Tani's argument and Dred Scott, where they were like, hey, I wanted to show that the northern states were also being racist as well with like their interracial marriage laws. And in this one, we had the same kind of, we don't really have much to stand on, so we're gonna put more fluff in regards of, hey, the northern states, they segregate schools too in Massachusetts, it's happening in DC, and it's like the same kind of angles we take when we're gonna just, hey, we know we're going way left from the Constitution, what it was meant to be, and we're gonna put this extra, when it has a extra racial feel to it, you know, hey, they're gonna build on with just, you know, different things. I think even they have they're talking about the inferiority complex in this majority opinion, and it's basically, you know, hey, it's inferiority because they're saying it, so it's not inferiority, right? It's what we say is inferiority, and I just feel like with this case, and especially Dred Scott, it's like the same thing where we don't have much of a constitutional ground to stand on, because we know the precedent we set in Yick Woo kind of, hey, what we're doing is completely opposite of that now, and it's just like, they start putting this fluff in there, and it just makes me think, like, when I look at the Supreme Court, it's like the Constitution, I feel, works, but you have people in power that can just kind of bend it and broaden it when they need to, narrow it when they need to, and I feel like in this case, like, they narrowed it a lot, and, you know, it's just one of those kind of observations I have, right, where it's like, hey, it just seems like Yick Woo, hey, we're gonna go one way because it wasn't blacks. But when it came to the blacks, that's why I just was wondering, what's the makeup of the Supreme Court right now? Like right after the Civil War, for them to be so anti-black per se, right after, you know, we fought a long war to get those amendments made. I'm like, what happened to the Supreme Court? Which is probably something we'll answer at another time offline, but just my observation that it's like, it just baffles me a little bit.
Yeah, well said. We're probably gonna go past 9:30. If you need to go, you can go, but I do want to finish this case. We have a lot of really good comments. I want to make sure, so if you need to go at 9:30, you can just get up and go, but I'll probably go a couple minutes past. I don't like doing that, but I think today's been one of those days. Yeah, but if you need to go at 9:30, you can just get up and go. So Drew raised a number of really, I think, astute points. I want to raise one at a time.
Will we be responsible for anything you say up to 9:30?
You can watch the video. I'm sorry. We had a good discussion today. So Drew raised a couple points I do want to take, and I do want to discuss, and some. I will get to Harlan as well. First, what happened after a long, bloody civil war, right? You had a huge war of attrition, right? Congress passed these amendments. They were ratified by the people. And then within the span of 20 years, it was basically gutted. And it's not difficult to see that the aim of these amendments was to help promote some sort of racial equality in one form or another. Yet in each case, which involved African Americans, the courts sort of zigged the other way. And trying to reconcile these cases, I think, is a fool's errand. I don't think you're going to be able to do it. Now, why was Justice Harlan the lone dissenter, right? He was actually an interesting guy. He was from Kentucky, a former slaveholder, but he joined the Union Army, and he actually freed all of his slaves, became a huge abolitionist, right? But at the time, even a number of the justices were Northerners. They weren't all Southerners. And I think they still had the idea that, okay, we fought the war, you got your freedom, then move on with your lives. And they have a couple of lines to the effect of, the purpose of these amendments was to put you at the sort of the same level, and then you guys are on your own. And Harlan, I think, viewed a little bit differently and said that there are still these remainders and vestiges. You can't shake off the bonds of slavery overnight, or even over 10 years, even maybe over 100 years, right? That will take a much longer time. And the court here was not willing to intervene. There are other cases which I don't assign, but they were decided roughly in this time period that go in a similar trajectory. I think I mentioned one last week involving a grandfather clause, where basically, I think it was Alabama passed a law that said, if you couldn't vote by a certain date, you can't vote. Okay, and duh. At the time, black people couldn't vote, so you know it was this weird sort of cutoff. And the court basically said, we realize this is a bad law, but we don't want to get involved as a censor of all these little things. Now, can you say this was because they were racist and they support this legislation? It could be the court said, we don't want to get involved because these people are going to ignore it. Or, another theory, what if the court had said, yes, Louisiana, you must integrate your rail cars, you must integrate your schools, you must integrate all your facilities. And the Southerners said, nope, not going to do it. We just fought Reconstruction, we're not going to do it. You fight another Civil War. So perhaps one theory is the court recognized that they weren't going to be able to do what they wanted to do, and so they sort of backed off. But that doesn't account for the sort of language which says, if you feel inferior, it's on you. It's your fault if you think this makes you inferior. And I mean, that language is quite arrogant. and I mean, a lot of words you can use, but it basically says, if this makes you feel bad, it's your fault, right? So it's your problem. All right, sure. That kind of get at your question. You put a lot of good stuff there. I want to make sure I address this as carefully as I can. Yeah? All right. Any other questions on the majority? And if you need to go, go. But I need another 5 or 10 minutes, and I'll let you go. Yeah, Mia? Yeah, just watch the video later, but you can go if you need to go. I'm going to keep teaching.
The distinction they draw between civil or political versus social rights.
Yeah.
So they just, like, public, like, enjoyment of public space. I guess, is this just going back to what those fundamental rights, essentially what privileges or immunities are?
Yeah. So there's a big distinction between civil rights and political rights. Civil rights would be things like owning property, or making contracts or riding on conveyances. Political rights, things like voting and things used to interact with government, serving on a jury, for example. And there's a huge distinction between civil rights and political rights back then.
Social is just enjoying.
Yeah. All right. I do want to get to Harlan. Any other questions on the majority in Plessy? And I can talk later if you want to ask more questions. I'll be here. All right. So let's go to Justice Harlan. Justice Harlan wrote a dissent that is cited a lot. If you had watched Judge Kavanaugh's hearing, he kept talking about Justice Harlan this and Justice Harlan that. And Harlan explains that the arbitrary separation of citizens on the basis of race while on the public highways is a badge of servitude. And for Harlan, he thinks that the fact that they're segregated on these public roads, make no mistake, these are not private trains, these are common carriers, public roads, that does run afoul of the 13th Amendment. But he also says on the 14th Amendment that the Constitution does not permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. And he has a very famous line. He says, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." And the exact opposite of the majority, he says, there is no superior dominant race or ruling class. With respect to civil rights, not political rights, civil rights, all citizens are equal before the law. And this is a very powerful message to be putting out in the 1890s, because no one else in the court took this position. And I want to just stress this point. Had Harlan not been on the court, this would have been a 9-0 opinion, 9-zip. And the benefit of having a dissent in a case like this is now 120 years later, law students from all walks of life can read it and say, wow, he was right and the majority was wrong. So the benefit of the Harlan dissent is to preserve for posterity that at that time someone else had a different perspective, that it wasn't just a one monolithic view, right? We'll do cases this year which were pretty awful, and there are no dissents attached to them, okay? Now, I want to mention this briefly. The idea of a colorblind constitution sounds wonderful. People say, yes, go colorblind. Not everyone agrees with that vision, because today we have cases involving affirmative action in which race is considered in an attempt to improve race relations. So is there a difference between using race in a positive fashion versus a negative fashion? Justice Stevens describes it using race as a welcome mat or a no trespassing sign, right? Is there a difference? And we'll come to that when we do the affirmative action cases later. But then Harlan goes to the police power, and he says that this is not a valid exercise of the police power, right? It's not reasonable exercise of the police power. Okay. Then we get to the part of the Asians, which is very strange. Justice Harlan taught constitutional law while he was a justice. You think you're lucky to have me. Imagine you have a justice in the Supreme Court. I'm kidding. As your professor. And this is pretty cool. One of his students in 97 or 98 wrote down all of his lecture notes verbatim, actually transcribed them. And those are in the Library of Congress. I actually digitized them. I actually scanned them and transcribed them. You can go read all of them. So I read all of Harlan's lecture notes. And I actually used some of his teaching tips that Harlan used. I used it in my own lecture. Harlan was very adamant that the freedmen, the freed slaves, would become Americans sooner or later. He believed that firmly in his heart of hearts. He said that these people will become part of our nation and have equality. He didn't feel the same way about Asians. He felt that they were a separate race altogether who still had loyalty to the emperor of China. And even in his lecture notes, he made these points very openly to his students. Like, yes, the Chinaman can never integrate. He was very brazen about this. How do you reconcile this? I don't know. These were complicated people. I don't pretend to understand it, but he firmly believed that Asian people have this loyalty to the emperor. They can never be part of a republic. Meanwhile, black people were born here. They can be integrated in our society. And he actually says, if you want a race that's not equal, go look at Chinese people. It's like, where the hell did that come from, right? A lot of case books edit that part out. We leave it in because I think it's thorough and comprehensive. But this shows even back then, the most racially progressive member of the court was out in left field in certain regards. So take that for whatever it's worth. All right. Questions on the Harlan dissent? Yeah.
Just an observation.
Yes, ma'am.
When he said that instead of trying to avoid aggression, this voting would actually stimulate aggressions. And I guess
good point.
It's scary when you look at it's almost like you'd be talking to us right now today, 2018, because when people are not seen, I guess, as equal, then there's an inferiority and a lack of fairness, protection of rights. Aggressions just get heightened. And so I think that what he saw and stated in his dissent is so true and applicable then and even now.
Yeah, very fair point. I agree. Yeah, James?
So do you think affirmative action will be challenged?
Well, we'll do affirmative action in a couple weeks. We'll get there, I promise. I can't. We're at 9:37. I can't keep people too late. I never say late, so I apologize. Is there anything else? You can ask me private one-on-one. All right, thank you all so much. I'll see you in class on Monday. Please do a sample midterm over the weekend.